Department of Justice has filed a motion to compel Apple to assist the FBI. Just because they've done that doesn't mean they have to, right? I mean, if you were advising Apple right now, what would they do? And at what point does it ever get to where they really have to do it?
Okay, right now this is definitely not an order yet. What this is seeking an order compelling them to do it. And so right now Apple's going to submit papers, oppose it. There'll be a decision, and probably whatever that decision is, the losing party is going to appeal it to a higher court. And I think this has the potential even to go all the way to the U.S. Supreme Court because there's so many issues that it raises.
So even if Apple loses in the first round, they appeal it and it just keeps on going.
Absolutely. And remember, Apple's concerned, too, about unleashing this technology into other hands, for example. It's not just a question of what happens in this case. Why is that important? Whether it gets into the hands of competitors, for example, that's a business issue. Whether foreign governments can then order them to do the same thing. And remember, you could be dealing with governments which are hostile to us, seeking to gather access to iPhone information.
And this is, Paul, this is a very different thing because looking, just sort of in the commercial breaks, trying to scan through old cases, anything semi-analogous to this would basically be the government saying turn over information. It was a case with Microsoft in Ireland and getting data off a server in Ireland. Last year, they got a lot of attention, basically compelling a company to hand over something. This is very different because this is the government telling Apple you have to build something. I don't know if there is a precedent for this.
I think Brian, that's definitely the key distinction in this case is you're forcing the company to do something. So, for example, there was information on an island or some underground location in the ocean. You're forcing a company to build a boat or submarine to get there. Can the government do that and force a company to take those affirmative acts? And the answer may be it depends how burdensome it is.
Correct me if I'm wrong, Paul, but in criminal cases, okay, I do damage to somebody. I've got an email, it's Gmail, Google's got it on their server. They can compel me through perhaps a warrant to turn over that email content.
And they've done that. Apple has turned over the information that was in the cloud.
And Apple has done that. And those cases, I don't want to say are settled, but there is some sort of a process. This would be the case of them asking Google to build a new email system.
Exactly.
Have you heard of anything like this?
I have not. And I think that's why this is an important case, because you're saying how much farther beyond producing what you already have do these telecommunication companies have to go to respond to a government request for information? And again, because the information nowadays isn't necessarily a piece of paper or a document, now you're talking about having to develop software and systems. And one of the things that Apple will probably argue is that it's very burdensome on them to force them to do that, and that companies should not be forced. And that may be one of the lines that a court's going to draw in this case eventually is how far can a company be forced to take action, incur expenses, perhaps even to use proprietary information to benefit a government request, which, again, traditionally, as you point out, if the information is on a server, they're going to have to produce it.
So this is a legal fight. It's a policy fight. It's also a PR fight. And inevitably, all these conversations go to this point, Paul, which is, what if there's information on that phone that could prevent another terrorist attack? If you were defending Apple, what do you say to that kind of argument?
I would say, look, you could go into certain houses in this country, open the door to every house in this country to look for information to stop an attack. But we don't do that. We don't say you can just walk into somebody's house. You have to have reasons. There's limits to how far you go to provide
But the FBI, Paul, is saying we want keys to this one house. We don't want keys to every single house. And the owner of the house is dead. So why not open that door for me?
Well, the owner is actually the county.
Well, what they're saying is that this opens the door to everybody's phones. We want to protect the privacy of our phones just as your houses should be protected.
What is the most compelling argument, in your view, Paul, that Apple could put forth? I mean, I thought the one about foreign governments could then ask the same thing. Foreign governments who may be hostile to the U.S. could ask for that same key to the kingdom that we are getting.
I think there's
scary.
Several. I think that's one, is that this opens the door to, again, hostile powers getting the information. It opens the door to criminals getting information. The burdensome aspect of this. I think there's many good arguments, and sort of the slippery slope argument, too. Where does this take us in terms of other requests for information? And again, as Tim Cook pointed out, I mean, there's information concerning medical history that we carry on these phones. And this, too, will be accessed at the same time.
But this isn't even a request for information. This is a request for the construction of a product.
And I think that's where the legal determination has to be made. Can the government do that to a company and force that type of conduct to be taken?
And we don't know if there is information on that phone. The phone could have nothing. I mean, obviously it has something on it, but it could have nothing on it, in which case they have just compelled Apple to build a whole new operating system to unlock a phone that contains no useful information.
Paul,
and that's one side of it.
Apple points out that they're using this law from 1789. It's an old law. The Constitution's old, so we still use it, right? So the fact that it's old doesn't necessarily mean that it's wrong. But what is it about the Apple's concern that the use of this writ of 1789 is problematic and that they're using it in a way that is overreaching? Can you explain that in a simple way?
Well, again, that old law from 1789 basically says the government can require a third party to help law enforcement. And what Apple is saying is, look, now you're dangerously expanding what you require a third party to do. And again, are you going to make us build surveillance software to help us, again, spy on people or gather their information? So again, it's a question of limits, like so many laws. But again, the Fourth Amendment is old also. We have to interpret old laws all the time.
Yeah, it's really, from a legal perspective, fascinating because there's a couple things here. Let's say that Apple gives in or loses. I guess, Paul, you could see a situation where the government could then come to Apple or Google or Samsung or anybody that's got anything with encryption on it and say, we think this terrorist has information on his phone. Nothing's happened yet. Now build us a product to get in. This is ex post facto we're talking about and so I think the fact that a crime has already been committed skews the legal thinking or at least the emotion around this, Paul, versus if Apple loses, the precedent maybe then could be used to say, well, by the way, okay, this guy we think is going to do something. We got some good information. Can you build us that? That's where the risk is, correct?
That's correct. And again, from the government point of view, this is a good case because it is a dramatic case. It is such a terrible case.
It's got emotion. The government has people on their side to say, damn it, 14 people are killed, and Apple just do it. But, Paul, if you were the general counsel of Apple, what would you advise them to do?
I would advise them to fight it because I think, number one, it is an unsettled area of law, and also that it does have potential risk to the company, I think, from a business point of view. I think it could require them to divulge proprietary information that could easily get into the wrong hands. I would also think that even if they lose this case legally, it helps them from a public point of view, that many consumers know that this company will stand behind them and trying their best to protect their privacy when that happens. And I think the concern you saw just a few years ago when iCloud accounts of several celebrities were breached, and again, that really created, I think, a security issue and perception problem for the company. So I think a company wants to show that it will do what it can to protect accounts of individuals or celebrities.